Hello, everybody, and welcome to this month's edition of Amicable Academy, which is a division of the Amicable Divorce Network. Amicable Academy is a different topic each month that is open to anybody in the public who might be interested in hearing about the topic. And this month, being October, we are doing DIY divorce nightmares and horror stories. And so our focus today is on things that have gone bump in the night and have gone wrong when people have tried to shortcut using the proper professional in their divorce case. And so what we're going to do today is talk about different perspectives and the different professionals that a person can use through the divorce process. Tony Scarpero is here as well as my co-host up there in the corner, and he's a certified divorce lending professional, which, yes, is a real thing. And that means that he has specialized knowledge in mortgages, refinancing, purchasing a home, anything that needs to be done, and has specialized knowledge about the divorce process and what we can do to help get you through the process and meet your real estate goals. So he's going to be jumping in after me, but I'm going to start today. We're sort of taking a little bit of a campfire format where we're going to go around and tell some stories. We have some members of the Amicable Divorce Network who have also sent in their horror stories. So I'm going to talk a little bit first and then turn it over to Tony. So for those of you who don't know me, my name is Tracy Ann Moore Grant. You don't have to remember all of that. And I am an attorney. I've been practicing now almost 20 years and only in the area of family law, and my practice is in Georgia. But in addition, I'm a mediator, an arbitrator, a parent coordinator, a guardian ad litem, and the founder of the Amicable Divorce Network. If you're not familiar with our network, we are now an international network and accepting members from all over the world to help us help parties reach low conflict divorce solutions. So we have an actual out of court process that our members are trained in to help parties reach a meaningful and informed divorce. And one of the things that we're very passionate about is that parties can receive a low conflict, low cost divorce with an attorney. A lot of people are very afraid of enlisting the services of a family law professional, or sometimes a different type of professional like a mortgage broker or a mental health professional, because they're afraid of the cost, the conflict that might bring to their situation, and a lot of fear of the unknown. And so we really try to reduce that. And one of the things that we do is we vet all of our members so that they are recommended or invited to join the network, or they apply and are vetted for being experienced. You have to have 5 years of family law experience. You have to be focusing on low conflict in your practice. It doesn't need to be your entire practice, but that needs to be something that you have a focus on and a passion for, and that you engage in fair billing practices. So we try to take that fear out of what is this professional going to be like to help people get through the divorce process. So as an attorney, I've been doing this for many years. And we've seen definitely over the past 5 years, a huge increase in people going to use online forms in order to get their divorce. There's lots of different ways that people can go about this. A lot of them are marketed, and I don't need to, name them here. And so I have seen the aftermath of some of this. If parties don't have minor children, they don't own real estate, they haven't been married very long, maybe a year or two, but have nothing complex about their case, doing the online forms may be appropriate for you. It may be very easy to fill out. But if you have minor children, if you are trying to calculate child support, if you have real estate, 401ks and assets, if you have any sort of tax issues, anything like that, we always recommend using a professional. So I wrote down a few things that I have actually seen in my practice where parties have tried to do it themselves. And these are actual cases that I've been involved in or try to be involved in. Sometimes it's too late, and I'll talk about that. So the number one problem that I see when people do it themselves is, number one, of course, you aren't attorneys. They don't have that experience or knowledge for writing those types of contracts. And so the number one thing that's missing is deadlines. So often people write up an agreement and they have no sort of deadline in it for when the other party is supposed to do something. And it's probably been about 5 years since I had this situation. But I had a woman come to me, and she was in their agreement, which had already been done, had been filed by the court. I wasn't involved. It was about 2 years after they had gotten divorced. Their agreement said that whenever the husband sold their marital home or refinanced it, she would get $100,000, which was the share of her marital equity in the home. They had been married for over 10 years. And of course, this is quite a substantial sum. And she was waiting to get that amount so that she could purchase a new home. She needed to be off of that previous mortgage and wanted her money. And I reviewed her agreement, and it had no deadline in there whatsoever. It did not say that he had to refinance by a certain date. Often when we're doing an agreement, we say at least 6 months now. Mortgages, and Tony could talk on this, taking a little bit longer than they used to. Sometimes longer. Sometimes somebody meets with Tony and they need more time to rehab their credit or things like that he can touch on, but there was no deadline whatsoever. And she was desperate to get this money. And there wasn't a thing that I could do. I did write him a letter trying to work it all out, but he had no legal motivation to refinance or sell. So that situation could have gone on into perpetuity until he decided to do either of those events. So unfortunately, with a property settlement in Georgia, you can't change it when it's done. And so she was stuck in that purgatory, terrible, terrible spot there. Another issue is that people think that the document says something that it doesn't. And so, or one party knows very well what it says and has tricked the other person because they did not have it reviewed by an attorney. So I would call this confusing terms. And so this language is very similar to the first agreement, but is different. In this particular situation, it said if the wife could refinance, that the husband would get $75,000. And that's all that it said. It didn't say, what if she doesn't qualify to refinance? It didn't say, what if she never tries to refinance? It didn't say anything like that. It just said, if she did, then he would get this. And there were none of these other contingencies in the agreement. And so it was very, very unenforceable. So one of the major things that we look at when we are an attorney is, if something goes wrong with this agreement, can I walk into a court of law and show the judge that the other person has violated the agreement? They have not met the deadline. They have not taken on certain responsibilities or undertaken certain acts. So a lot of that we see being missing when people try to do it themselves. A third issue that we see is that parties don't include the proper language about child support. So there's a couple of issues with this. And when people do it themselves, I see two major problems. One is that parties who are doing it themselves often are so agreeable with one another that they waive child support. And so they simply say, well, you don't need to pay me anything. We're really working this out. And there could be a situation where you have a huge disparity in income, so that the law would actually, in Georgia, this is where I practice, want there to be an amount of child support, because the presumption is that the homes should be same. The child support is meant to equalize the child's experience in each home. And so a lot of times parties are so agreeable and they just want this process to be done that they waive some important legal rights. And so one of them is the child support issue. The other thing that we see in Georgia is, for example, with uncovered medical expenses, a lot of times people will also just say, well, we'll just split that 50-50. The same with extracurricular, daycare, camps, things of that nature. And that actually, again, may not be the case. If somebody makes 80% of the household income and has gotten the other party to sign up to not pay child support, usually we do that based on income shares, or we could negotiate if there is child support for a different amount. But time and time again, I see people coming to me saying, I can't afford to pay for my children's expenses or my power bills or my groceries or things of that nature. And I see agreements where the financially not as well off spouse has just waived child support for no reason. And so just because you want to be very agreeable doesn't mean that you have to, give away the farm, so to speak. There are, when there's an attorney involved on both sides and everybody's giving practical legal advice, which is what we do in an amicable case, then it's, a very informed for both parties and hopefully fair result, but everybody's still negotiating, working within those parameters. The other thing is, this came up a lot during COVID. I had people contacting me saying, we don't know what, and these weren't parenting plans that I did. I just want to be clear. These were people who had parenting plans in place and were like, we don't know what we're supposed to do. I need to file a modification. I need to do such and such. And the main problem when I started looking at these parenting plans to try to help people, the main issue was they had not accounted for every hour of the day for the child. And so the biggest example that I saw was they might say, for example, the dad has the children starting on Thursday after school until Tuesday return to school. And then mom has the kids from Tuesday after school for, a certain period of time. And that, when you hear that, you may think, well, that makes total sense. But we have two problems with things being written that way. One is, what if there's no school? So when we say after school, we also then want to define a time, for example, or 4 p.m. if school is not in session, which was, of course, happening with COVID. The second situation you might not have picked up just from me saying that was that dad was returning the children to school Monday. Mom was picking them up from school Tuesday, but nobody was in charge of them during Tuesday. And so in your mind, you think, well, the children are sitting in the school, so they are with the school. They're not supposed to be with either parent. But obviously, when everything shut down with COVID, people were working from home. We're really trying to nail down these custodial schedules. And some of them that we were looking at, we were like, well, we don't know who has the child at lunchtime on Tuesday because it just absolutely isn't even in here. The other backup to that is, if we're not in the middle of a pandemic, who is in charge if the child is home from school that day? Maybe they get sick or have to be picked up, or have a doctor's appointment scheduled during that time. So that was one thing that was really a problem that we saw during the pandemic, were just parenting plans that didn't have all of the days and times for the child on lockdown, so to speak. The last thing that I've seen with people who do it themselves is, almost last, second to last, I guess, is people signing up for things that they don't have to. For example, in Georgia, and this isn't true in every state, support for a minor child stops when they graduate high school or turn 18, whichever happens later is generally how our provision is written. So sometimes I get paperwork and it says that the parties are to split college expenses. And usually I'm getting this paperwork because one party can no longer meet this obligation. Maybe it snuck up on them Maybe they just didn't prepare for it or they didn't understand. But I've seen provisions written so poorly that say the parties will split all necessary college expenses for a child. And that's very detrimental in a couple of ways. One is that that's a very loosey-goosey and not very good provision, because it doesn't say anything really about how long the child might be in college, or that they need to maintain a certain GPA, or in-state versus Harvard. Do they have scholarships? What is necessary? I mean, they might think necessary is, you know, living in a very nice apartment as opposed to student housing, things of that nature. But also the other issue is that because they've signed up for something that the Georgia court couldn't give them, if you had a trial and you're standing in front of the judge cannot say that the parties have to split college expenses. It can't be changed. So that person, you know, they could have been in a car accident, they can be disabled, they could have had the best of intentions to want to share in the college expenses, but they cannot. And so that actual provision cannot be changed. And what technically happens in those situations, because the child is the beneficiary, is you get into these contempt actions that involve college-age children wanting their expenses to be paid, or the other parent wanting to be reimbursed for what they have paid on that child's behalf. The last issue that I've seen with people doing it themselves and trying to just really cut corners is navigating the actual court system and the forms. Every jurisdiction is different. Every county in Georgia is different for how they handle divorces. Do they make you appear in court? Some judges do, some judges don't. Often with COVID, we have done away with a lot of those requirements, but not everywhere. Does the judge even know that your divorce is ready to be finalized? Have you met the parenting class requirements for that jurisdiction? But the biggest hiccup that we see is that the parties just don't know how to fill out the very technical forms properly. One of the biggest forms that we have is the child support worksheet. The numbers in that worksheet have to match exactly to all of the other documents and have to have certain boxes checked in other documents. And the judge's office and the clerk's office are not able to give people legal advice. So what we see happening time and time again is parties, even during COVID, because they were still trying to get people work through the court system, would have people show up for these hearings, whether they are in person, which some of our judges here never stopped really doing, or on Zoom. Even so, parties have taken their day off work usually to accommodate for this hearing, and the judge will say, your paperwork is not complete. You need to go to the law library and get this sorted out. And they don't know what that means or how to do it. And so they often spend many, many months. I've been working with somebody who, you know, is just coming in and getting some advice and still trying to do it themselves for over 18 months. And during that time, circumstances change, that original agreement doesn't make sense anymore. You also then start running into tax consequences. So your tax status is whatever you are on December 31st. So if you're still married on December 31st, that's putting you in an entirely different tax bracket than you may have anticipated. So Halloween time is always scary, I say, for family law attorneys, because this is sort of our time of year that if parties want to get divorced in that calendar year, we need to get a move on. We need to be making sure we get that paperwork done, that we get it to the court, because judges often do not sign documents as quickly as the parties need them to. So you want to give them as much time as possible. Especially if nothing has even been filed with the court yet. So that's always sort of the holiday for family law attorneys to be thinking about is, oh no, it's Halloween. I need to start getting a move on for the end of the year. So those are some of the highlights, certainly not everything that I have seen that parties in a case trying to do it themselves can't get through the system with and have some problems. But at this point, I'm going to mute myself and I'm going to turn it over to Tony.
Hey, good afternoon, Tracy. Thanks for having me. For those of you that don't know me or we haven't met, as Tracy mentioned, my name is Tony Scarpero. I'm a certified divorce lending professional. Practiced in Atlanta for almost 25 years, and then now recently, about a year ago, moved out to Colorado. So I'm licensed to do mortgages here in Colorado, Georgia, Florida, and Alabama. If you're in a state outside of that, I can certainly help you as well, and also refer you to somebody else that is also a certified divorce lending professional in another state that I don't work in. Part of my experience is I have been divorced, so I've been down this path and understand it very well myself. And working as a certified divorce lending professional, some of the things that Tracy touched on, we see quite commonly. And some of the biggest, I would say the two biggest horror stories or mistakes that we see happen, and this doesn't necessarily happen just with do-it-yourself, pro se type of representation. I see it happen even when people have divorce attorneys involved where they haven't consulted with someone like myself in the process. But probably the number one thing that I see happen is around timelines and expectations around that, similar to what Tracy talked about, is that majority of the time, we see that one of the parties, when they own real estate, one of them is going to end up keeping that property. Not always. Sometimes they end up selling it for a number of reasons. But a lot of times, whoever is getting the home awarded to them in the divorce, what we'll see happen a lot of times is that they will put the timelines too quickly. And what I mean by that is in a scenario where maybe the person that's being awarded the home is also going to be getting child support and or possibly alimony. And maybe they need that portion of income to actually qualify to refinance as well. Maybe that income is going to be in addition to what they may be earning outside of the household, or maybe they've been a stay-at-home mom, stay-at-home dad, whatever the case may be. And we see this happen where the parties will agree saying, okay, this person that's being awarded the home needs to complete the refinance in 90 days from the divorce being finalized. And the parties will think, oh yeah, 90 days should be plenty of time. It's not going to take that long to process a mortgage. And it generally doesn't. Mortgage refinance typically will take about 30 to 45 days if people have everything together. But the problem becomes when they try and do that in 90 days from the divorce being finalized, and if they are getting alimony or child support, and if they need that portion of income to qualify, just about every single loan product out there is going to require to show proof that that person that's been receiving that child support or alimony has been receiving it on time for the amount specified for at least 6 months or longer. Then the other thing that comes into play with that is for both child support and alimony, those amounts need to be continuing for at least 36 months. So one of the things that we refer to quite often in mortgage lending is the 636 rule, which is just that, of that they need to have been receiving that income for 6 months, and it needs to be continuing for another 36 months from the date that the refinance is completed. So that is one of the biggest things that we see happen, is that they can't do it in that amount of time. And so we end up having to delay that until they are at like 6 or 7 months from the divorce. A lot of times you end up having an ex-spouse that's very unhappy about things. And, occasionally you'll see things get contentious and contempt actions filed and things like that. The other big issue that we see happen, again, this doesn't necessarily happen with or without an attorney, but more times than not, when there's not an attorney involved, is that we will see in the division of real estate, the party that's being awarded the marital home, instead of it specifying that they're going to be awarded the home and that they're going to refinance it into their name, I see this happen quite often where the settlement agreement actually specifies that they're going to purchase that home from the other party. We actually just had one very much like this about 2 months ago. Gentleman, he was actually receiving the home and he was supposed to purchase it from his ex-wife. there were two huge problems that existed there. One was that he didn't have the down payment amount that he would have needed to purchase the home. I think that they had agreed on a purchase price of $500,000. I'm not really sure where they came up with that value from, but and so in the wife's eyes, she was going to sell the property to him for that amount, and that was going to be her net proceeds. Well, the problem, in addition to him not having the down payment, was that he already was on title to the home because he was already on the mortgage that existed with his ex-wife or soon to be ex-wife. Both were on that mortgage, both were on title. So technically he couldn't purchase that real estate because he already owned it. So that one actually took quite a bit of navigating. We could not change their settlement agreement, but we actually had to get an exception to be able to underwrite it as a refinance, is what it should have been. And in that same regard, when they went to get their appraisal done, it actually appraised for quite a bit more than what she was looking to try and sell the property to him for. So that ended up with a lot of confusion around how much proceeds she was going to actually get. So it just really, really complicates things when the parties don't fully understand what their outcome is that they're looking to try and do, but the mechanics around exactly how it needs to be spelled out and written, just like Tracy said. If things are written very vague or loosely or not described in such a way of what they're actually trying to do, is going to complicate things big time. And so one of the other things that we see happen is, regardless if it's done as a do-it-yourself or if attorneys are involved, is clients not getting involved with a mortgage broker early in the process, thinking that maybe, well, I don't need to go apply for a loan, or I don't even want to talk about my situation because it's too complicated and the mortgage lender is not going to understand it. So I'm just going to wait until everything's done at the end. And that's one of the biggest mistakes that people make, is not engaging with either a certified divorce lending professional or even just a lender in general to understand what they're going to qualify for in, if that's 6 months or a year down the road, because these processes, sometimes do take, 6 months to a year. And so understanding what they're going to qualify for, what sort of limitations or hurdles, and how to strategically plan through that. That is one of the biggest things that I do as a certified divorce lending professional, is being able to somewhat look into the future, right? To be able to look at what that scenario is going to look like on the backside of things. And in theory, okay, if they're making this much money, these are the debts they're going to have. Are they going to qualify to do what they're trying to do with the marital home? Maybe they don't. And maybe the right outcome is actually selling the home and then purchasing something down the road. And that, those conversations also, regardless of which party is getting the home, a lot of times it's the one, that's not being awarded the home, that they're going to need to look at that as well, of what their housing situation is going to look like post-divorce. And, if you're looking at negotiating, large division of assets, of cash, or is there going to be alimony involved? Those things can be worked through and done in such a way with the numbers so that everybody has what sort of outcome that they're looking for at the end. And it's a very specialized thing to look at. In Georgia, there's less than 20 of us that are certified divorce lending professionals out of literally thousands and thousands of loan officers. So regardless if I can help you or not, you can look at the Divorce Lending Association website, just divorcelendingassociation.com. And you can literally search by state, by zip code and city, and find somebody that's in your area, or reach out to me as well. But I would say, Tracy, those are really the biggest, most common mistakes that we see is around dividing the real estate and how they're going to finance it and how they're going to actually go through that process and make sure that the terms and the paperwork and their settlement agreement is done properly.
I agree. We see that quite a lot, like I was touching on, where people don't really understand the complexities of real estate and financing, and they sort of draw it up the way that they want things to be and using language that makes sense to them. but from a legal and financial standpoint may not be doable. And we're dealing with huge sums of money and sometimes huge tax consequences with that. So I see Lauren Loper on here. Lauren, you had sent in a horror story. Do you want to just present it for us live since you're here?
Yeah, sure. Absolutely. So, whenever anybody says that they have gotten divorced and they have a settlement that is requiring them to sell the home, normally what I try to do is I always think of Tony. So if I'm talking to somebody that has a home and they haven't, had the settlement yet, then, I like to say to look at everything with them in terms of pointing them in the right direction before they even think about, getting money from their house, because that's what they're thinking about. I mean, they're either things are working out fine or not, amicably or not, but they are always thinking about the money and how they're going to get the money. Where's the money going to come from? So when they have a home that's a, marital asset, I try to listen to, okay, well, have you talked about maybe refinancing or taking money out of refinancing, or refinancing that your spouse can have it because you have, or your ex-spouse will have it because of the kids. Talk about the insurance, a homeowner's insurance, and a couple of other things that I want them to think about before, they think about, or if the settlement hasn't come out yet and they're still in the discovery phase. But if it does come out where I'm the last to hear about it, where, hey, I have the settlement, we have to get it on the market. I had a client just recently, it was 5 days before the end of August. I have to get this house listed by August 31st, according to the settlement. So it's like, okay, but making sure that, we're getting the house listed. But on the other side of things is I've also several different things, but one in particular recently, a client had, with a settlement agreement, they needed to sell 2 homes and they were using a family realtor to help them because they were getting a deal. And he mentioned that they both had their attorneys. And this is where another thing where, I'd like to rely on attorneys to have the expertise, but I also understand that an attorney is an expert in the field of, legalities and there, but oftentimes they, don't know the complexities of real estate as well. So they're like, well, we'll just get an evaluation. We'll just get, we'll just say that the house needs to be sold by this time. But they're missing some pieces on making sure that they're directing their people to the right professional. So, but anyway, in this case, I had this client who he's selling 2 homes, but he reached out to me to buy. And so he's like, well, these need to sell before I can purchase. So that'll be in about a month. Well, things have already started to crop up where he contacted me and he's like, my ex-wife is trying to claim all the money on the homes, which will not leave me anything. I'm like, well, what is the settlement statement? What's the settlement say? What does your attorney say? And then also, he also discovered that the car that was in both of their names, that she literally just got it repossessed. So now his credit's in the toilet. And now he's like, how am I going to buy a house? So the funding issue with the sales of the house got worked out, but now he can't buy a house because who was there to help him along the way to say, let's monitor the credit. Let's make sure, who's doing what in this whole divorce process. What is the wife committing to? What is the husband committing to? Are they trying to sabotage the credit at this very moment as we're talking or not? So, those are some of the things where if I can get with people who are thinking about divorce or just starting the process or just starting that discovery or right before, mediation, if I can get with them and talk about the house and the certain things that might impact the sale or the refinance, which I normally just, of course, always get Tony involved in, or a divorce mortgage lender expert in. So we can start to be looking for these things that are going to impact their financial future. So.
Thank you, Lauren. I think you touched on something that's really important, and that is I'm an attorney and I've been doing this for 20 years, and I will freely admit I'm not an expert in all of the different areas that touch on a divorce. So how could a layperson also be able to manage all of these different aspects? So, one thing that's very valuable about our amicable divorce network is that all of the right professionals are just a phone call away. So whether it's, I'm in mediation and I need to send, Tony an email to say, does this sound right to you? What do you recommend, here? Or reach out to a CPA or, somebody like that for whatever it is. The right professionals who have training and expertise are available and are not going to, a lot of people are afraid of their case getting blown up, and so that's what we really try to control, is that that's not going to happen with this, group. We're all here to help you, but help you get it done properly, because, I'm not an expert in real estate or mortgage or, taxes or anything like that, but we have people to help who are. So I think something I tell people a lot is this is the most important transaction of your life. A lot of times it involves all of your assets and including your children, taxes. Do it properly. So many people, you go to a car mechanic to get your car fixed, you go to a doctor, to get some medical help, but they are so fearful of using the right professionals in their divorce. And the fear is what, sort of conflict and cost is that going to create? So we really try to manage those fears with this process. So thank you guys. I have a couple more nightmares that were sent to me from other people in the network. So let me go to those. So one of them was from one of our mental health professionals, and she asked to be anonymous. And she said that she has seen several clients who did not use attorneys because they were bullied by the other spouse, and they were fearful of the other person, of upsetting them. But there was just a power dynamic in the marriage that one person just had a very strong personality. And they've seen where, because that person didn't get an attorney, they've signed up for things that they really shouldn't have and things that can't change. And the situation just continues. So she was saying she always recommends for people to go get an attorney. Of course, like we all know as professionals, people don't always listen to us. But she said it would be very helpful, especially if people don't feel on equal footing with the spouse and have had these power dynamic issues. So that's important to know. One of our financial professionals sent in, they were trying to work with parties who had already reached a divorce settlement, had done it themselves and had filed it, gotten it through the court system, didn't have minor children, but they had a 401k that needed to be divided, and it just said somebody was going to get a certain amount from the 401k. It had no deadlines, again, like I touched on. And it was supposed to be a very substantial sum, over $200,000, and they did not know that they had to do a quadro, and nobody had done it in years. So for those of you who may not be familiar, when you have a 401k as an asset in a marriage, and you all have reached an agreement to divide it, and sometimes you have to do that. Sometimes it's your only asset, or you do want those 401k dollars. There's lots of different reasons you might come to this result. But for a 401k division, it is required that you actually do what's called a qualified domestic relations order, which sometimes is as complicated as it sounds. And so this document is another court order that the judge has to sign that is done based on that exact plan's requirements. So for example, if your 401k is at Fidelity, their form is totally different than the form that you might have at Edward Jones or something of that nature. So there's professionals who do this, they charge for that work. Sometimes also the plan administrator, meaning Fidelity or another company, charges to process the quadro, and we've seen those fees be as high as $2,500, and parties just don't know that. But if you do use the quadro and you divide those funds, it's not a tax event to either person. So the person who has the 401k is not getting any sort of withdrawal penalty. The person getting the money isn't getting any sort of income penalty. It's just a tax-free transaction pursuant to divorce. But I've also seen, touching on what this person has said, where people had no idea that quadros existed and they cashed out part of their retirement to pay the other person, took a tax hit on that because they didn't know that this was available to them as a tax-free procedure. And there are professionals who do them sometimes $500 to $850, depending on how complicated they are. That's far cheaper than any sort of huge tax bill you get for cashing out your 401k or a portion thereof. So that is something I've seen also. I forgot about that one. That one was pretty bad. That person had cashed out quite a substantial sum and had taken a hit on it. So Ginger, who's here, is a mediator out of Florida and an attorney, had a horror story. Ginger, do you
Tracy.
want to share with us?
Sure. Yeah, I had a situation where the parties did the divorce themselves. And unfortunately, the husband, after the divorce was finalized, he passed away. And the former wife came to me and said he was supposed to refinance the house and get it out of my name. And so I looked at the divorce agreement, didn't say anything about that. Didn't say he was supposed to refinance, just said she was supposed to sign a quitclaim deed, sign title over to him, which she did. So she signed title over to him. Title was no longer in her name, but the mortgage was still in her name. And so his heir was her former mother-in-law, who did not like her very much. And so when she contacted the mother-in-law and said, well, are you going to pay the mortgage? You can imagine what the mother-in-law said to her. And so her credit was, in the tank. She came to me saying, what can I do? And I said, there's nothing here that says that that he had to refinance. There's nothing here that you can really do other than to file a claim in the probate to see if, the probate court can give you some kind of remedy. But that's one of those things where if there was an attorney involved, the attorney would have said, well, you do not sign that quitclaim deed and it does not get filed until the day of the refinance. And it all gets done at the same time. The quitclaim deed gets filed at the same time as the refinance is done and her name is removed from the mortgage. So if she had seen a divorce professional, she would have known that.
Very good point. I think Tony, Lauren, I bet we've all seen this as well. I've gotten documents as well where people think by executing a quitclaim deed, you come off of the mortgage. And so they use language like sign a quitclaim deed or sign over the house to the other party, all these sort of languages and things that don't accomplish what they want it to. So a lot of times people have good intentions of reaching a certain goal, but just need some additional assistance in order to get there. Thank you, Ginger. That was a really good one. Yes, a lot of times people don't think about this. I think we've started to see people think about it a little bit more with the pandemic. What happens if someone dies during the divorce? Maybe once a settlement is signed before the final judgment and decree, and am I covered after the divorce? We send all of our clients a letter, now that you're divorced, do all of these different things about insurance, taxes, your accounts. And a lot of people don't know or think about that to tie up all of those loose ends. So I want to thank everybody for joining us today. If you're here on the video, you're welcome to stay after we stop the recording and chat a little bit and share some more horror stories. I want to thank everybody who has watched us here on YouTube today and tuned in. Thank you very much to Tony for being my co-host today, and for everybody who has shared their horror stories. The moral of the story is get the proper professional to help you through this very important time in your life. Get it done properly, or it could definitely leave you with some nightmares later. So if you need assistance, we're always happy here to help you at the Amicable Divorce Network. We have professionals all over who can assist you. And you can always email me at info@amicableddivorcenetwork.com if you have any questions at all about utilizing the network or becoming a member. Thank you guys very much, and we'll see you next month.